Welcome back, everyone. In our last chapter, we learned how agency relationships are formed and what duties agents and principals owe to each other. Today, we're taking the next step. When an agent signs a contract, who is legally responsible? The agent? The principal? Both? And what happens when an employee causes harm to someone while working? These questions are answered by agency liability law. Let's dive in. The most important question in agency law is, did the agent have authority to act? Authority is the legal power of an agent to bind the principal to agreements with third parties. There are 5 major types. We have express authority. Express authority is directly given by the principal. It may be written or oral. For example, a company tells the purchasing manager, "You may buy up to $50,000 of inventory." The manager now has express authority. Key point: authority comes directly from the principal. Now let's move on to implied authority. Implied authority is not specifically stated. Instead, it arises because it is necessary to perform the job. For example, if a store manager has express authority to run a store, the manager has implied authority to hire cashiers and order supplies. Key point: so implied authority helps carry out express authority. Apparent authority. Apparent authority exists when a principal makes third parties reasonably believe an agent has authority, even if the authority doesn't actually exist. For example, a company allows a former employee to continue using company business cards. Customers reasonably believe the employee still represents the company. The key point is that apparent authority is based on appearances created by the principal. Now let's move on to emergency powers. Sometimes emergencies happen. If the agent cannot contact the principal and immediate action is needed, emergency authority exists. For example, a property manager authorizes emergency repairs after a major flood. The key point being that emergency powers protect the principal's property and interests. Ratification. Ratification occurs when an agent acts without authority but the principal later approves the action. For example, an employee signs a contract without permission. The company later accepts the agreement. The key point being that ratification makes an unauthorized act legally authorized after the fact. Okay, the 3 types of principals. The law classifies principals into 3 categories. Disclosed principal. The third party knows an agent relationship exists, and the principal's identity. For example, you know you're buying from Apple through an Apple employee. There's partially disclosed principal. The third party knows an agent is acting for someone, but doesn't know who the principal is. For example, a buyer says, "I'm purchasing this for a client." The client's identity remains a secret. Next, we have undisclosed principal. The third party does not know an agency relationship exists. For example, a celebrity secretly sends someone to purchase property. The seller thinks they're dealing only with the agent. Next, let's move on to contract liability. This section appears on many exams. Let's simplify. So, authorized agent plus disclosed principal. Principal is liable. Agent is not liable. Authorized agent plus partially disclosed principal. Principal is liable. Agent is also liable. Authorized agent plus undisclosed principal. Principal is liable. Agent is also liable. Third party can usually choose whom to sue. Unauthorized agent. Principal is generally not liable. Agent may be liable for violating the implied warranty of authority. The agent essentially promised they had authority when they did not. So, for easy memory, there's a rule. Disclosed principal pays. Agent walks away. Partially disclosed or undisclosed principal and agent may both pay. Unauthorized agent pays. So, next let's move on to tort liability. Contracts aren't the only issue. What if an agent injures someone? Principal's own negligence. A principal is liable for its own negligent actions. Examples include improper instructions, unsafe equipment, and dangerous workplace rules. Authorized torts. If a principal directs an agent to commit a tort, both may be liable. For example, a company orders an employee to legally trespass, illegally. Both can be responsible. Misrepresentation. If an authorized agent makes false statements to customers, the principal may be liable. For example, a salesperson lies about a product's capabilities. The company can be held responsible. Negligence and respondeat superior. This is the biggest tort concept. Respondeat superior. The employer is liable for employee negligence occurring within the scope of employment. For example, a delivery driver caused an accident while making deliveries. Both driver and employer may be liable. Exam phrase. Within the scope of employment. If the employee is doing their job, the employer may be liable. Detour versus frolic. Courts distinguish between detour, which is a minor deviation from work duties, and in a detour, employer remains liable. For example, stopping for coffee while making deliveries. But there's a difference between detour and frolic. Frolic is major personal activity unrelated to work. Employer is not liable. For example, driving 30 miles away to visit friends during work. Okay, intentional torts. Employers can be liable for intentional torts committed within the scope of employment. For example, a nightclub bouncer assaults a customer while performing security duties. Okay, next let's move on to independent contractors. Generally, the employer is not liable for an independent contractor's negligence. Exception: ultra-hazardous activities such as blasting, explosive, toxic chemicals. And let's talk about crimes. Agents are liable for their own crimes. Principals usually are not liable unless they participated in or authorized the criminal conduct. Section 5. Termination of agency. Agency relationships eventually end. There are two major methods. Termination by act of the parties. So we have lapse of time. Agency ends when the agreed upon time expires. Achievement of purpose. Agency ends when the assigned task is completed. Occurrence of a specific event. So agency ends when a specified event occurs. Mutual agreement. Both parties agree to terminate. Revocation or renunciation. Either party ends the relationship. Next, termination by operation of law. Agency automatically ends due to legal events. Examples include death, insanity, bankruptcy, impossibility, war, major changed circumstances. So let's do a quick review. Remember these key points. Authority types: express, implied, apparent, emergency, ratification. Principal types: disclosed, partially disclosed, undisclosed. Most important tort rule: Respondeat superior. Most important contract rule: authorized acts bind the principal. Most important termination rule: agency ends by acts of the parties or operation of law. Agency law determines who is responsible when agents make contracts, commit torts, or act on behalf of others. If you understand authority, liability, and termination, you've mastered the foundation of agency law. Thanks for watching, and I'll see you in the next chapter. Bye.